Hey everybody, this is Randall with PARSOL again. Thanks for joining us for part 2 on this series on our unique right to reputation here in Pennsylvania. I'm in front of the Supreme Court today in the Capitol in Harrisburg, and we're going to pass it off to one of our legal committee members, Josh, who's going to tell you about some of the cases that this very court has seen that made some important decisions affecting this unique right that we have in this state, the right to reputation. And in 2023, this court is once again going to tackle that issue when Torsilieri is given his day in court.
Hello again. This is Josh with PARSOL. Thank you for joining me as we continue to explore Pennsylvania's unique constitutional right to reputation. If you haven't seen the first installment of our Reputation series, we looked at the creation of reputation as a fundamental constitutional right in the Commonwealth of Pennsylvania. Now, we've already established that a right to reputation is constitutionally preserved, but we know that certain freedoms and liberties can be denied to people who are convicted of crimes. An obvious example is the right to travel while a person is incarcerated. We also know that other freedoms, such as the rights of free speech and freedom of worship, are maintained despite conviction. Where does Pennsylvania's constitutional right to reputation from? Does a person still have a right to possess and protect their reputation after they've been convicted of a felony? Or is this forfeited? In the 1874 case of Smith v. Stewart, the Supreme Court of Pennsylvania explained that although a felony conviction ruins your reputation, serving your time in prison is supposed to restore your reputation by paying your debt to society. Quote, "A convict in prison is a walking monument of whatever the common mind loathes in reputation." In English law books, conviction and attainder are often used synonymously. An attainder is defined to be the stain or corruption of blood of a criminal capitally condemned. A penitentiary, with us, is the lazar house of sin and crime, where the beautiful ideal of the law supposes that the solitude and repentance will expiate and wash away the guilt, but which in the common mind only deepens the disgrace. A bold thief, never convicted, is not half so bad in the apprehension of the common mind as one detected and convicted, who comes abroad with the odor of the penitentiary upon him. There is some chance for one in the world, but little or none for the other. The quote from the court is powerful, not only for answering the question in the positive, but for also contrasting the idea of a societal debt paid with the continued cost of a damaged public perception. I think this court would put the responsibility of helping a person restore the reputation on the government. After serving a sentence, the Commonwealth ought to provide re-entry and job training, counseling or life coaching, and official commendation. Contrast this ideal with the situation many people with sex offenses or persons forced to register things. 15 years, 25 years, or a lifetime of being listed on a public registry that details your crime in perpetuity and which presupposes that all people listed on it are dangerous degenerates. Because peer-reviewed studies have demonstrated the ineffectiveness of Megan's Law at reducing sexual offenses, the Public Sex Offense Registry has an erosive, rather than protective, effect on society by making it harder for people to re-enter and thrive. If serving a sentence legally restores your constitutional right to reputation, then you could, in theory, sue anyone who libels or slanders of your prior convictions after you've completed your sentence. The Pennsylvania Constitution's Article 1, subsection 11 reads, "All courts shall be open, and every man for an injury done him in his lands, goods, person, or reputation shall have remedy by due course of law, and right and justice administered without sale, denial, or delay." While truth is a complete defense to libel and slander accusations, under Smith, once you've completed your sentence, your prior convictions are no longer true. You're no longer a convict or an offender. You are no longer guilty. In economic terms, once you've paid that debt, no one can bill you for it again. A zero balance can't be added to a future debt. The right to reputation could be interpreted as a right to expunge all past criminal records once your sentence is finished. It makes completing penal sentences more meaningful. An important analysis of the fundamental nature of reputation to residents in Pennsylvania comes from Erdman versus Mitchell. This case in the Supreme Court of Pennsylvania from 1903 asserts that you do not need litigation or legislation to protect reputation because our founders explicitly addressed this and other rights. Erdman versus Mitchell reads, the first article of the Constitution, Pennsylvania's Constitution, says that the general and essential principles of liberty and free government may be recognized and unalterably established. We declare that all men are both equally free and independent and have certain inherent and indefeasible rights, among which are those of enjoying and defending life and liberty, of acquiring, possessing, and protecting property and reputation, and of pursuing their own happiness. Then follows the conclusion of this section. Everything in this article is accepted out of the general powers of the government and shall forever remain inviolate. This clause, unlike many others in the Constitution, needs no affirmative legislation, civil or criminal, for its enforcement in civil courts. Most recently, here in Pennsylvania, State Attorney General Josh Shapiro wanted Catholic bishops to release the names of priests who were accused of sexual abuse in the 2018 Pennsylvania grand jury. In the 2018 opinion for In the Interest of 40th Statewide Investigating Grand Jury, Justice Deborah Todd wrote for the majority, quote, as the content of Report 1 is condemnatory of petitioners, we conclude that principles of fundamental fairness demanded enhanced procedural protections be afforded petitioners in order to safeguard their right to reputation. Though controversial, the court ruled that the priest's name would not be released. This is because they were not yet proven guilty, and their reputation would suffer from accusations of sexual abuse being made public. On top of that, many of the priests were already dead, making it impossible for them to defend themselves. William Penn's vision for reputation has clearly been seen through, and I think he would be pleased of how our state courts have interpreted his ideals. We need the State General Assembly to also recognize the right to reputation as an indefeasible quality that our founders guaranteed the people of Pennsylvania. When it comes to people with sexual offenses and the need to protect the public, our legislators must rely on research and evidence-based approaches as their guide and allow their emotions and reactions to come second. All people in Pennsylvania have the right and means to restore their good names, even those who have committed sexual crimes. We must honor our Constitution as it is written, even when it causes us to have to grapple with difficult and uncomfortable scenarios. PARSOL's bylaw states, once an individual has completed his or her criminal sentence, his or her debt to society should be considered paid, and no law, whether criminal or civil in nature, should prolong or add to that sentence. Nor should any law or registry hinder his or her right to reputation. Thank you for joining me in this series of Pennsylvania's unique constitutional right to reputation. You can find more useful resources in our Resources tab on our webpage at parsol.org. If you find this content useful, then please like and share this series with your friends and family. Subscribe to our channel, as even this helps us grow and reach more people. See you in part 3.